Well, hey again, everyone. It's Rob Ryder on Sunday, January 21st, 2024. And did you know that the Supreme Court of the United States has ruled that the term United States is a metaphor? It can be used for lots of things, apparently. So we're going to be talking about that. And it had something to do with what I was working on since my last video. And then another thing happened just here a couple days ago, which compelled me to surrender to military authorities, which I just sent in my written statement today. We'll see if they act on it. But let's start with that a little bit. Now, let's finish up with who I am. So I'm Staff Sergeant Rytlewski Robert Allen. At least that's what my DD Form 4 has me identified as, right? They have your last name, first name. Okay, well, if that's how you want to identify me, fine. I'm Staff Sergeant Rytlewski Robert Allen, Soldier for Life, also known as Rob Ryder, and my email address is courtofrecord@aol.com. YouTube is Rob Ryder, ROBBBRYDER. So, since my last video, I was working on what I was going to do next, and that involved looking at trying to file a claim with the Comptroller General of the United States, because in my previous video to that, I tried to file a claim to the Secretary of the Defense. And in both cases, it has to do with the fact that I've not been discharged. I don't have a discharge order in my records. I don't believe any enlisted person has a discharge order in their records. In the name of the individual that went to the MEP station and enlisted. So in other words, I went in as Rytlewski Robert Allen. That's how my DD Form 4 identifies me. But there was never any orders ever issued in that name. They were always Rytlewski Robert A. And so I'm saying, hey, if I don't have an order, I'm still in the military. So I don't have one. I'm in the military. Well, then I want my pay, because according to the DD Form 4 agreement, right, that as long as you're enlisted, you're entitled to pay, they use some other words, right? Pay something or other and other benefits. Not allotments, but, yeah, we'll get to it. So, that's one of the things I've been going for quite some time now, is to be able to collect that. Well, and so I've done all sorts of things. I've sent complaints to Inspector General's offices and various other things. So, and to the Army Review Board. Well, so last Thursday, just this last Thursday, just as I was sitting down to eat, I hear the phone ring. So I didn't go answer it. It's in the other room. Couldn't hear what they're saying. I was eating my dinner. And I got done and I said, okay, let me go out and get some wood and bring it in and, fiddle fart around for a bit. And pretty soon it's, no longer 5 o'clock. Now it's closer to 6 o'clock. I finally go in to see who had called, and I see that they had called again, same phone number, 2 times. And so I hit my button on the message machine, and by gosh, it's somebody from the Army Review Board calling me. He wants me to call him back. And the second time he said, please call me back as soon as possible. So, okay, well, I guess I'll see if he's still there. And, he was. And, but he wasn't calling me about the complaint case I had submitted to the Army Review Board. He was calling me because he had gotten a call from the Army Human Resources Inspector General, which I thought was quite interesting. And he wanted to talk about my being, confirming that I was not a deserter. Right? Because it was one of the things I had complained about, and we'll show the paperwork again. But on my DD Form 214, right, which has nothing to do with if you're out of the military or not, but they want to make it sound like that's the document that proves you're out of the military. But on mine, I never signed it. So I was discharged in absentia. And in absentia is only done for very few reasons. You're physically unable to do it, or you're, AWOL, away without leave. And eventually AWOL leads to, being a deserter. So it's like, okay, was one of the things I had complained about on some of these different complaints I had done. And so he's calling me to tell me this. Oh, okay. And so we got it worked out, and apparently he had to talk to me first so he could call back to the Inspector General and give him his report. So that led me in a little search on some other things, and that's why I've decided, well, what I need to do is surrender to military authorities and stop trying to do all these other things I may have been trying to do. Well, I'll keep doing them until something works, but that the first step for me, or for any enlistee who believes that you're just a veteran now, right, with no ties to the military, I say, well, if you don't have a discharge order, you're still in the military, and you're supposed to be paid, and we're basically involuntarily absent, but we're still on duty. As long as you're on duty, you're getting paid. And, that's what I wanted to file. So that is what I filed to the Secretary of Defense. And just days after I filed it to him, his office, he disappeared. How does that work? Right? And then he wound up with prostate cancer or something, they said. Or really knows where he went to, but he disappeared. So, what else was I going to do after that? And that's what we're going to be talking about. So, anyways, let me load up a couple of things here, and we'll start working through some of these, I don't know what you call them. Right? They just stick out. It's like, well, when you ponder some of these things, it gets to leads you in different directions. So, let's see where we are. Yeah, and so I'm not taking credit for this. Rosita sent me this, and it's like, well, ain't that some shit? Where it says, the court, this is from the Supreme Court, has ruled that the term United States is a metaphor. It's a figure of speech. Right? In this court case here, 262 U.S. 100, 122, and that the term United States may be used in one of several senses. It may be merely the name of the sovereign occupying the position analogous to that of a sovereign in a family of nations. Well, if people are sovereign, that could be me, right? I'm the United States. That's what I immediately jumped on. And it went on to say, well, it may designate territory which sovereignty of the United States extends. And that's how it's normally used. You see it used in a lot of laws. They say, when they define what the United States is, they say in a territorial sense, it's, blah, 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 blah. They're talking about the territory of the United States. Or it may be a collective name of the states which are united by and under the Constitution. Okay, so the state of Michigan is the United States because it's one of the collective states that's under the Constitution. Right? Not state of Michigan, not Michigan, the state of Michigan, which is what was the term that was decided in the first Constitution of Michigan. And I know it's kind of hard to read, but it says Constitution of Michigan of 1835, and in the preamble, we the people, blah, 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 and then it gets on to talk about the ordinance of the Congress of the United States of the 13th day, July 1708-7, and the acts of Congress passed in accordance therewith, which entitle us to admission into the Union upon the condition which have been fulfilled, due by our delegates in assemble, mutually agree, to form ourselves into a free and independent state by the style and title of, wait for it, the state of Michigan, right, with the T capitalized. So that's the proper name of Michigan as far as it being in the United States. It's not state of Michigan, which they use all the time. They never use the state of Michigan to identify Michigan in Michigan. It's always state of Michigan, right? Which is the democracy, the thing that's supplanted the sovereign state. And so the state of Michigan, because it's part of the Union, has been guaranteed a Republican form of government by the United States. But we don't have one, right? We've been overrun by a democracy run by esquires. All right, so the reason this is important to me is, well, if I can say I'm the United States, then I can file for free with the courts of the United States. It's in their fee schedule. which is one of the other things we're going to look at here in just a minute. What the fee schedule says from the people who make the fee schedule, and what the fee schedule says from the court that displays the fee schedule. They're not the same. So apparently they're not the same court. It's not the court that was spoken about by the people who first published the fee schedule, which is some group of circuit judges make up a judicial committee of some kind. Right? They set the fees for the other courts from this committee, but that isn't the fees that are being displayed on your district court's website. And some other anomalies. So let's get into them. Hang on a second. But one other thing I want to get, I've been wanting to say this for quite some time, and I haven't really had a place to put it in a video, so I'm going to do it right now. This is out of Title 38 Code of Federal Regulations, right, CFR, which has to do with the Veterans Administration, in the definition section. And if you go down here far enough where you see patient, right, so basically any vet who's gone to the clinic or to the hospital, you're termed a patient. So the term patient means any individual or subject who has applied for or been given a diagnosis or treatment for drug use, alcoholism or alcohol abuse, infection with human immunodeficiency virus, or sickle cell anemia, and includes any individual who, after arrest on criminal charges, is interviewed and or tested in connection with drug abuse, alcoholism, alcohol abuse, infection with human, let's just call it HIV and make it easier, or sickle cell anemia, in order to determine that individual's eligibility to participate in treatment or rehabilitation program. The term patient includes an individual who has been diagnosed or treated for alcoholism, drug abuse, HIV infection, or sickle cell anemia for purposes of participation in VA program or activities related to those four conditions, including program and activity consistent with treatment, rehabilitation, education, training, evaluation, or research. The term patient for the purpose of infection with human HIV, right, or sickle cell anemia includes one, tested for the diseases. Okay, well, it doesn't exclude anybody. It just says it includes them. So even if you haven't been tested for those diseases, they can give you a diagnosis that says you have it. It's sort of like a COVID test. This one's a negative, that one's a positive, or hey, they're all positive. We don't really know. Orange gets a positive from taking a COVID test. Banana gets it. The dog gets it. All sorts of people got, according to the test, have COVID. Or inanimate objects have COVID. So I just think it's very interesting. They make anybody who's a patient has this stigma added to them, which has to have something. It's like, now we need to be under constant care or something. We're Typhoid Mary or something. So it's part of a scheme. I don't really know how it all fits in. I just know, well, why would you go to all this trouble unless it's part of a scheme? Okay, so if you've been following along, these last 3 videos I did, it was on duty even when involuntarily absent, which I believe I am for the reasons I already said. We'll get into it more in a little bit. And then, well, what do you do about it? Well, I want to make a claim under 31 U.S.C. 3702, right? Authority to settle claims, which says in there that if it has to do with pay, any kind of pay for military, that you give your claim to the Secretary of Defense. And you have to get it to him. And so I tried to do that, and I used the address that they give online to do it, and following the tracking on USPS, United States Postal Service, because I had sent it priority mail, it never made it to the zip code that the Secretary of Defense is assigned to. It went to another zip code, and then it was picked up by somebody. But that isn't how shit works. So it's like, well, somebody obstructed the mail. Well, what are you going to do about it? That's the point. So at that point, I sent a Inspector General complaint to the Inspector General of the Department of Defense. Okay, carry on. What are you going to do now? Now that's done. Well, as it turns out, in the footnotes of 31 U.S.C. 3702, it talks about this other public act that when you go to it, it says that the Comptroller General, that all claims for or against the United States will be settled in the office of the General Accounting Office, GAO, General Accounting Office, which is under the Comptroller General. Right? And it says claims and demands. And then you start to look at what these definitions are, and a demand is actually a claim, where the word claim is actually a lien. So the demand would be that you send your demand to the, therefore, this is the way I'm looking at it, to the Office of Comptroller General as a demand, making your claim of what it is. And then if they don't give you relief, then you can take it to the Court of Federal Claims, which has authority to adjudicate military pay issues. Right? And that would be the claim. So that's more like a lien, right? You're putting a lien against the United States for not meeting your demands. So that's what I was looking at, you know, the idea of. So it's okay, if I make up this demand, then first thing I do is make sure that they know it's my signature, because they keep talking about this. And so I went through all that in the video where, you know, it's not just you signing the paper, you have to have witnesses. And if you have witnesses and a notary, that's called a self-authenticating affidavit. But you can also use an attestation statement and two witnesses, where you're just going to do things under penalty of perjury and don't have to have the notaries. Now you just need to have 3 people, right? And the other 2 are just going to witness your signature. You know, so that's the way it's supposed to work. Okay, do all that, and then I was going to send it to the Comptroller General at the address that they give in the law and so forth. But I wanted to first make it a public record, right, that I had done this thing, because, you know, I don't want to disappear again and say, well, what was it? Well, here's a public record. And, you know, I couldn't find in the law where I can do it at the county, although I believe I should be able to put it in the county. But what I had seen was a fee schedule for the district court. So I got to find that real quick. Hang on. All right, district court miscellaneous fees. So this is federal district court. All right, United States Courts website. So it's www.uscourts.gov. Where it says, first of all, it says right here that the United States should not be charged fees under the schedule, with the exception of 2, 4, and 5. Okay, well, when I was reading at that time, I didn't know the United States is a metaphor. It's like, well, okay, well, now I understand that's a metaphor. I say I'm the United States, therefore I don't have to pay a fee, because I'm doing what I'm doing from within the United States. And I have to show you when we get to it, right? But what it said was, for filing any document that is not related to a pending case or proceeding, $52. So even if I wasn't the United States, if I wanted to file a document at the district court that has nothing to do with any pending case or proceeding, I could do it for $52. All right, that's what it says. That's the fucking fees. And then I had this other fee at the end where it talks about processing fee for offense charged on a federal violation notice, $30. Now, they have this document, it's called the United States District Court violation notice or something like that. That's what its title is, but it's really a citation, because it's saying you either have to come to court or not come to court. It's much more than just a notice of the violation of a federal statute. It's saying you have to come to court. It's a citation. So that isn't what this is talking about. I say this is if I was to say that there was something wrong, you know, an offense against the United States, against the law, that I should be able to put that in and get a judge to take a look at it. All right, okay. So anyways, and then it says issued under 28 U.S.C. 1914. So let's go look at that real quick. All right, 28 U.S.C. 1914, District Court Filing and Miscellaneous Fees, Rules of Court. The clerk of each district court shall require the parties instituting any civil action, suit, or proceeding in such court, whether by original process, removed or otherwise, to pay a filing fee of $350, except that on application for writ of habeas corpus, the filing fee shall be $5. The clerk shall collect from the parties such additional fees only as prescribed by the Judicial Conference of the United States. Well, we were just looking at that. That's what this is, right? These are the fees determined by the Judicial Conference. Okay, so here's the fees. Now let's go look at the fees of, let's say, the United States District Court, Western District of Michigan, where it says civil case filing fee, $500. Well, hang on a minute. This said the clerk of each district court shall require the parties instituting any civil action, suit, or proceeding in such court, whether by original process or removal or otherwise, to pay a filing fee of $350. Well, a civil case is not, mentioned. It says a civil action, a suit, or proceeding. It had nothing to do with a civil case. And yet, right, that's what they're saying right here. They only give you one choice. Civil case, $405. There's no $350. Where the hell's the $350 at? There's something they adding up here, folks. Okay, and then it says, clerk shall collect from parties that such additional fees only as prescribed by the Judicial Conference, which is fine. Let's go back and look to see what some of those might have been. And one of them in here is like collecting a $50 fee. Where is that? Administrative fee for filing a civil action, suit, or proceeding in a district court, $55. This fee does not apply to applications for writ habeas corpus or to persons granted form of pauper status, da-da-da. Right? So this would be you starting a suit. This is like the initial document started suit. It's $55. But none of that adds up to what they said here, right? Nobody said you could put the fees together and you could use civil case to stand for specific words in a law that have been used. So whatever the law says, do what the law says. And obviously they're not doing it. They got a thing here for miscellaneous case filing fee of $52. But it doesn't say anything about filing a document that's not related to a pending case or proceeding. Now, I get that could be an initiating document, but it didn't say initiating documents. It said any document. So if I wanted just to file something there so that it would be, on file, it'd be a record of it, I should be able to. And it used to be that this said, because you can see this changed December 1st, 2023, where they talked about if you wanted to preserve testimony, right, that you could file documents. Well, now it just says any document. So that's what I wanted to do, and then I started to find these differences here. It's like, well, there's a problem here, right? Well, then, on top of that, leave it to Rosita. She found this other golden nugget, which is if you go here to 28 U.S.C. Chapter 5, which is about the district courts, it'll list all the states and the district courts. And so for Michigan, I'm 102, right? So now we got to go down to 102. 102, where are you? Nebraska. 5, we're getting close. Yeah. This is Michigan. Western District. The Western District comprises 2 divisions. Southern Division has these counties. Court for Southern Division shall be held in these cities. Northern Division has these counties. Court for Northern Division shall be held in these cities. So I'm in the Southern Division. But anyways, and let's say the North. So altogether, you have Grand Rapids, Kalamazoo, Lansing, Traverse City, Marquette, and Sault Ste. Marie, all those cities should have a district court. You know, or the courtroom for the district courthouse, court building, whatever, right? It's where that's supposed to be held. Now let's go look real quick then at, where are you? Right, so here's United States District Court, Western District of Michigan. Court locations. We got one in Grand Rapids. We got one in Kalamazoo. We have one in Lansing. We have one in Marquette. Well, there's 4. The law said there's 6. Right? So there was no mention of Traverse City having one. And there's no mention of Sault Ste. Marie having one. So apparently this court here, right, is not the same court that's talked about in the law. It's just acting like that court. Right? It's simulating being somebody that it isn't, because there's not a court everywhere there's supposed to be. Well, that's fucked up. Well, there it is. So I complained to somebody about that. You know, one of these places they had an email address thing, so I sent something in just to bitch. Because that's all you could do. I mean, you're sitting at home by yourself. You don't have a lot of authority over these people. Well, you have all the authority. You don't have much power. You have all the authority. What we need is the power. That's going to come from the sword. But that's what they're doing. Right? They don't have the proper fee schedule, because that's where this fee schedule I showed you came from, is this court here. And they don't have all the courts listed. Well, then you're not the freaking place that's talked about in the law. Right? 28 USC, Chapter 5. And then, so it wasn't just this state. Rosita checked for Illinois. It's the same thing in the Northern District. There's supposed to be Chicago, and I think it's Wheaton is the other city. Well, Wheaton doesn't have a courthouse. Right? They don't hold court there, or at least they're not advertising they're holding court there. I'm sure that they are, because that's what the law says, but that isn't what this place is that we're looking at. This place is pretending to be the court that has that authority. Right? We've been infiltrated by esquires. It's a conspiracy, which isn't a theory, it's a freaking crime. It's a conspiracy against the United States. Right? So I said, well, okay, well, how about the freaking appeals court? Right? United States Court of Appeals for the 6th Circuit, which is where Michigan is. How are they doing things? And one of the things I had found on this site, though, which was completely different, was they have these instructions on there that appellate ECF account holders, right, which is electronic filing, right, appellate ECF account holders, may submit petitions for review in original proceedings without payment. I said, well, that's what I want to do. That's like petitioning the government for redress of grievances. It shouldn't cost me anything. So, yeah, that's what I want to do. I want to petition the government for redress of grievances through the appellate court. I need to get me an appellate ECF. Or I need to get myself authority to do that. So if you have a Pacer account, you could do it. Resubmit form. I got to resubmit. Hang on a second here. So, if you're trying to do electronic filing with the federal court, they're going to send you to Pacer and say you got to open up an account, right? So I have had a Pacer account for quite some time, but I hadn't necessarily tried to use it for, filing. But what these directions said then, right? You want to go to the page where you have CMECF startup page appears, select utilities. So that's after. It's if you have the account already. This is how you get the account, though. You're supposed to go under this maintenance tab, which I'm under now, and you can go to non-attorney e-file registration. If you click on that, then you can pick the type of court. Let's say a court of appeals, and see the 6th court isn't there because I already have it. This is the point. I have e-file registration authorization. But if I wanted to do it again, I pick another one because you can do this many different courts as you want to. Fill in the blanks, yada, yada, yada. Okay? So, well, what if you've done that? How do you know if you haven't? Well, then it says check e-file status. U.S., right? U.S. Appeals Court. Now, see, it doesn't say United States Court of Appeals. It says U.S. Appeals Court. U.S. Court of Appeals, Sixth Circuit, not United States. It's not that there isn't room to put United States in here. They made a conscious decision to use U.S. We'll get into that in a second. The important thing is I have an active registration. So I should be able to file into this court. Unfortunately, right? That's not the name of the court on the first page. It's the United States Court of Appeals. They didn't say U.S. Court of Appeals. They said United States Court of Appeals. Then you go down here and look, well, welcome to the Sixth Circuit Court of Appeals. It's at the Potter Stewart U.S. Courthouse. But really, when you go up and look up Potter Stewart Courthouse, the proper name is Potter Stewart United States Courthouse, not U.S. Right? This is a conscious decision to change United States into this acronym or this contraction called U.S. So what does that mean anyways? Well, as it turns out, where did I get this from? I guess I want to show where it came from, and then we'll read it from where I'm getting it from. All right, this is Books, Manuscripts, Submission Guide, the Army University Press, which is a military email or a military website. Right? It's a official website of the United States Lower G government. And I'm reading this stuff down here, but like I said, it's a little bit too hard for me to read, so I needed to make it a little bit bigger. So publisher's note. The Army University Press supports the professional military education of soldiers and leader development. Books are published by our press that describe the historical facts pertaining to the American Civil War and acknowledges that the legacy of that war is still at the forefront of our national conversation because the Civil War never ended. Lincoln declared martial law. It's never been rescinded. And according to Lieber Code, once martial law has been declared, there's three ways to change it, and none of those have ever happened, so that martial law has never ended. And it was over the United States. I'll show you the general order that he did it with. But for now, for example, first of all, we intend to describe the political and social situation of the Civil War in a neutral manner. For example, the traditional terms to describe the opposing sides, North and South, are only used for grammatical variety, as they ascribe generalities that certainly did not apply to the totality of the North or the South. Many local citizens who resided in the states that are openly rebelled against the United States government were not in favor of secession, nor did they believe that preserving slavery warranted such a violent act. Similarly, citizens in the states who remained loyal to the United States did not all feel a strong commitment towards dissolving the institution of slavery, nor did they believe Lincoln's views represented their own. Thus, while the historiography has traditionally referred to the Union in the American Civil War as the northern states loyal to the United States government, the fact is that the term Union always referred to the states together, which clearly was not the situation at all because some of the states had seceded. In light of this, the reader will discover that the word Union is largely replaced the more historically accurate federal government. Federal government or U.S. government go with the Civil War. All right, Union forces and Union Army will largely be replaced by U.S. Army, Federals or Federal Army. U.S. Army, which is on the frickin' left, over the left pocket of every member of the military of the Army, says U.S. Army. That's a Civil War term. Right? It means that you're loyal to the Union, right? But the Union has been dissolved. There's been, I won't say dissolved, that's really wrong. Certain states have seceded. So anyways, it goes on to say the Reconstruction policy between the federal government, that would be the wartime government, and former rebellious states saw an increased effort to control the narrative and how the war was fought, which led to enduring perpetuation of the lost cause rhetoric, which basically says the war's still going on. However, the Army doesn't believe that that's true. It goes on. I can't read this whole thing. It would take too long. But you see what I'm saying, right? If you're using the terms U.S. Army or federal government, you're talking Civil War, brothers and sisters. War's still going on. And under the martial law government then, veterans who have not been released from the military because of the fact that we went in during a war or a war started while we were in, and I went through all that in other videos, right? We may not be on active duty in a unit, but we're the eyes and the ears of the commander-in-chief in the field. And so we see that the contractors who've been hired to supply all the things that a government would normally supply. I think there's like 17 of them or something like that. It's a list of things that the government's supposed to supply. Well, if the government is under martial law, then the Army has to do it. And they're not going to do it with officers of the United States. They're going to do it with contractors. And none of these people have, that we now believe the government, have a oath of office that satisfies the 6th article of the Constitution. State officers or United States officers. No state judge, not your governor, not your Secretary of State, not your Attorney General, no FBI agent, no IRS agent, no. Even the Congress, no, they didn't take the proper oath. They are not of the United States. Right? They're an invading army. And they call themselves the United States of America. In fact, they changed the fucking Constitution. The Constitution Congress uses in Article 2, the very first sentence says that the executive power resides in the President of the United States of America. But you go to the Constitution that the Army uses or the military uses in the Manual of Court Martials, it says that the executive power resides in the President of the United States. Well, my oath says I have an oath to the President of the United States, not the President of the United States of America, so Congress ain't got a damn thing to do with me. That may be their Constitution, but it's not my Constitution. And, we've been invaded by esquires, which by definition is a crown agent. They've taken over our government. They've taken over the wartime government that is subject to the military. So, I've been saying we need to go to the military to get an answer, which is one of the many things I'm trying, but that would be why. So back to filing for free with the circuit court, right? Even though I have, by their rules, I have the frickin' authority to do so, they haven't allowed me to do it yet. Right? So I wasn't able to do this. So anyways, but I kept looking and I saw this thing about e-filing information and I filed that, and it said, because here it talks about filing original petitions, right, without payment. That's where I got the information from that I showed earlier. It also had down here filing original petitions via email. So I tried to send one via email, but that's not the same as electronic filing. And it said that if you have, although the way it was written, if you have this ECF authority, you're supposed to be able to file for free. So I said, I'll just send it anyways. And maybe I'll read it here in a little bit what I sent to them. But, that right now that's where it is. It's with them. We're going to see if they do anything with it. But the interesting thing is it says original petitions, right? So what exactly is that? Well, our form of government is based on the laws of England, right? English common law, which William Blackstone wrote the book on, that the founding fathers used as the their reference to how they were setting up the government. And he says that in Book 3, Chapter 18, of the pursuit of remedies by action of first of the original writ. Right? And so this idea is you have to get this thing called original writ to start your court case. Where it says, first then, the original or original writ, which was the beginning and foundation of the suit, when a person had received an injury which he thinks worth his while to demand a satisfaction for, he is to consider with himself or take advice that redress the law has given for the injury, and whereupon or thereupon is to make application or suit to the crown, the fountain of all justice, for that particular specific remedy which he determined or advised to pursue, as money due on account, or any consequential injury received, special action on the case. To this end, he is to sue out or purchase by paying the stated fees, I believe it should be, an original or original writ from the Court of Chancery, which is the shop or mint of justice, wherein all the king's writs are framed. It's a mandatory letter from the king in parchment, sealed with his great seal, and directed to the sheriff of the county wherein the injury is committed or supposed to be committed, requiring him to command the wrongdoer or party accused to either do justice to the complainant, that would be me, or else appear in court and answer the accusation. Whatever the sheriff does in pursuance to the writ, he must return or certify to the Court of Common Pleas, which I believe that would be then the district court, not the Court of Appeals, but the district court, together with the writ itself, which is the foundation of the jurisdiction of the court, being the king's warrant for the judges to proceed to determine the cause. For it was a maxim introduced by the Normans that there should be no proceeding in common pleas before the king's justices without his original writ. So if you're going to federal court and you don't have an original writ, you're wasting your fucking time. Right? You're not doing what's supposed to be done to start a court case, because our system of law is based on the laws of England. And it starts with this thing called an original writ, and they have a thing called an original proceeding, right? Original petition. So you're going to petition for original writ. Seems to make pretty much good sense to me. So, like I said, in here had this PDF. Appellant ECF account holder may submit petitions. So I'm trying, and they won't let me do it so far. But attorneys have this also, so they could do it for you. And they could do it for free. All they have to do is be willing to do it. If they have an appellant ECF account holder, well, they can submit a petition for review or original proceedings without payment. It can't be any more clearly written. It doesn't say pay later. It just says you can do it without payment. All right, so all that was trying to use the courts, right? Then, like I said, I got this call from a guy that he's a retired lieutenant colonel, and that now works the Army Review Board. And so as he's talking, I think, well, shit, he's saying, well, we could, because it was all about this right here. He was calling because he said he got a phone call from the Inspector General of the Human Resource Command about this fact that I believe I may be a deserter because I have DD 214 that I didn't sign. Right? Member unavailable for signature. And regardless of what branch you're in, if you want to know what goes in all these blanks, because this is a DD form, right, 214, so it would have had to have been filled out according to the DOD guidelines. Although each branch may have their own regulations for it, and the Army does, right? They have this regulation, which is AR 635-5 on separation documents. And then another one, AR 635-8 on separation processing and documents. And in both of these, it'll show you what's supposed to go in each box. Of a DD 214. Right? So And it'll say, you read the fine print, it'll say that no deviations are allowed, right? So this wording here isn't proper for this box to start with, right? So I may not have signed it, which I didn't, and they're supposed to put a particular phrase in there, and that phrase isn't right. It goes on and on and on. Well, they also gave me the separation code of JBK, and so when you find yours, you want to know what that means, go to AR 635-5-1. All right, separation program designators, SPD codes, or whatever branch you're in, you may find your own. If you want to look at it to see what they are, well, here's a place to go. And so, the one I have, JBK, says it was an involuntary discharge under AR 635-200, Chapter 4, Note 7. Well, that is kind of what it says here on mine, right? There's separation authority, AR 635-200, Chapter 4, 7. Well, you go down lower, well, they could have gave me a KBK, which is the same thing, completion of required active service, right? Completion of required active, same wording. Again, this wording is supposed to be exactly like this, and we'll see that it isn't. But there it is, same thing, except this has note 1. So if we go down here far enough, we'll find the notes, and we'll see that these notes have to do with your eligibility for reenlistment. So they gave me a 7. So except for those with a DCSS, which is a Declination of Continued Service Statement in force. So that would be something that would have to be in your records. I don't have one. To be used for RA, regular Army soldiers, ineligible for, barred from, or otherwise denied reenlistment that are separated on completion of enlistment. So if you have a note 7, it means they're not kicking you out. They're going to let you go to your last date, but you can't reenlist. Or this one up here means basically the opposite. You can reenlist. Well, if you look at mine, I got a reenlistment code RE1A, which at the time that would mean I could reenlist without any, there was no bar to my reenlistment. And that's what the guy who called me said. No, you had no bar to your reenlistment, and you can reenlist, and And he said, well, probably what will happen is they're going to close that case and give it to us, and then we could just issue a new DD-214. I said, no, I don't want a new DD-214. I don't have a discharge order, right? I want to be returned to military control and collect my back pay. That's what I told him on the phone. It's an interesting conversation we had there for a little bit. But what I didn't say is what the words that probably needed to be said, because they're specifically in this Army Regulation 630-10, absence without leave, desertion, administration personnel involved in civilian court proceedings. And in Chapter 4, it talks about being returned to military control. And what does it say? Return to military control. Absentees and deserters are returned to military control when they surrender to military authorities. 1. So if you surrender, you've been returned. You just got to figure out who the military authority is. So one of the guys I'm going to call is this colonel tomorrow, this retired lieutenant colonel at the Army Review Board, and say, how do I surrender to military authorities? Sir, I accept your oath and bind you to it. Remind you of your fiduciary duty. So that was, that's my idea. That's what I want to be able to do. But at the same time, because he had said he was calling because of the Inspector General of the United States Army Human Resource Command, HRC, I said, well, I'm going to send it to the Inspector General and tell him that I want to. Right? So, how does somebody sitting at their house today who's a veteran reestablish their relationship with the military? Well, you'd have to return to military control. Now, I had shown in my one of my previous videos, one of the last couple previous videos, that, like in my case, I was in for 3 years and I got out. Then I stayed out for a year and went back in. I stayed out long enough, I had to re-enlist. It wasn't like I could just have it be a, what would you call it? leave of absence. I had to re-enlist. But what I had found in one of the Army regulations I was looking at is that if you've served 3 years and you still have a commitment, it says right in the regulation that they're supposed to issue you a DD Form 2 identification card, a Geneva Convention identification card. Well, they never did that. Right? So, I mean, it was just proof that at that point you're still in the military, but they didn't issue a card. And I'm saying, well, I don't have a discharge order, so I'm still in the military, even though I don't have a card. Right? So I want to surrender to military authority because I am involuntarily absent. So I told the Inspector General, right, Redlusky Robert Allen, because that's the way it is on my DD Form 4, that's how they identified me, surrenders to military authority. Inspector General, on my oath, I'm an involuntary absentee from the Armed Forces of the United States, and I surrender to you, a military authority, in accordance with Army Regulation AR 630-10, Chapter 4. In order to be returned to military control, that'd be that RMC, to restore my honorable service, collect pay and allowances, and then retire. Please tell me where to report or send the MPs. For the record, I have an ongoing case with your office under case number, blah, 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 and I am identified as Redlusky Robert Allen with that Social Security number on my DD Form 4 re-enlistment document, Armed Forces of the United States, included as an attachment. Thank you for your service. Right, so I mean, this is how you just get around all this shit of trying to file a claim with somebody. Just, surrender to the military. Get your record straight and then claim what you want because you'll be back in the military. They'll give it to you then. Once they know you're there and that, it's a big mistake somehow, they'll be happy to write you a check. Because in this regulation, Army Regulation 600-8-6, which is not a really good one to download just to get an idea. It doesn't really matter what branch you're in. Personnel, accounting, and strength, you'll find out that they've had a duty to account for you 24/7 every day that you're in the military. And they're supposed to, put it in a particular system and which if I come to those, I'll show you. The primary authority document for correct soldier status is normally an order. So I need an order written to correct my status. I get it. I got the wrong status. And, if you've been watching me long enough, I've sent in paperwork trying to get this Army military human resource record, and they wouldn't send it to me. And, it's the authoritative document in there. And this AMHRR has not just your official military file that you get when you go to the national records, but it has this other stuff to do with pay and so forth, which doesn't necessarily go to your official records. Right? But it's still a frickin' record they're keeping. It's like, well, they won't let you see what it is. Right? And that the Electronic Military Personnel Office, eMilPro, is the only approved system to account for regular Army and Reserve mobilized soldiers on active duty tour, So, right, check me out on eMilPro and find out what I am. If it's not right, then we need to fix it. Right, soldier accountability is the responsibility of commanders at all echelons during peacetime mobilization, combat, or other types of deployments. Commanders and staff will ensure 100% PA, which is personal accountability, of all personnel for the duration of the military service. Well, they can't prove that I've been discharged, so it's not my fault, it's theirs. Right? The unit commander will account for their assigned and attached personnel by verifying their full name, Department of Defense Common Access Card, your DOD ID number, and or full Social Security number. So either by your DOD ID or your full, 9-digit Social Security number. SSN. Well, there we go, right? Because the thing on your ID card, or you got for Social Security, that's your SSAN number, Social Security account number. It's not necessarily your Social Security number. It's a fucked up system, but it's the way she works. PA is the recording and visibility of by name management, right? By name. So does that mean by my name or some other name that is my by name. Because, you ever see where people sign for other people, they'll say by and then they'll sign. So is that what that is? I don't know what a by name with a hyphen is. This is a grammar thing. What does by name with a hyphen mean? What I know it means is the PA is the recording and visibility of that management of location and duty status of all personnel assigned or attached to a unit. Okay, and I really wanted to get down to this really important part, which is military personnel office, what they're supposed to do, recording, email pro is the only approved system. I think we saw that already. Let's cheat. And this is what I wanted to get to. All right, these are the different duty status codes. These are all on duty status codes, right? So you're still in the military, on duty, and out of that then they have this list of codes, and there's, I don't know how many there are here, 20 different codes that you could be and be on duty. Let's see what some of them are. Administrative absence, absent without leave, captured, confined, hospital, interned, missing in action, and then my favorite, missing. Soldiers whose whereabouts and status are unknown, provided the absence appears to be involuntary. The type of casualty code can either be hostile or non-hostile, only authorized to use. Okay, so missing is one of the things that falls under captured. And if you're captured, you're still in the military and you're getting paid. You've been getting captured, you've been getting paid, you've been getting promotions, just like you were still in the military. And it's all gone to an account that's handled by the Secretary of the Treasury, who's taking it to buy bonds and other safe sorts of things. And it's built up to some, God knows how big it is, but it's there. It's yours. Now, if you got out and during this missing time, you had another job and you made a shitload of money, well, they're not going to pay you both, right? But, at least you'll be accounted for. You can get your retirement. But if you didn't do all those things and, you didn't work, well, then you have it coming to you, right? That money is yours, right? Ordinary leave, present for duty, sentence for 30 days, sentence military authority, sick, temporary duty. All of these are considered as on-duty duty status codes. So let's get it figured out, right? The only way to do this is got to be returned to military control, and then the military does what they do, check the right boxes, and change the records. But until you're in the military, they can't do it. Okie doke. Well, I'm going to stop here, and if something happens with the document that I filed with the circuit court that I had to send through email instead of being able to e-file, I'm still trying to get the e-file worked out. I'll do that in another video. But what I want to say about it is what I was trying to do in that one is to make the state of Michigan, the plaintiff, ex-rel, Ritluski Robert Allen, right? Because the United States of America is part of the Union, therefore it's the United States, therefore it should be able to file for free. Right? And what I was pointing out is that the state of Michigan is denied a Republican form of government because the state has been invaded by esquires. And I went on, I've shown this in many different videos, that, Whitmer doesn't have the proper oath of office. She didn't take the oath to satisfy the 6th article of the Constitution. And the oath she filed that's supposed to be for the state of Michigan and its Constitution wasn't done properly. She had it administered to her by an officer that's unauthorized to administer oaths to state officers, and that would be a notary public. So it had to be a judge or I think a mayor could do it. Things that are only certain offices can administer an oath to a state officer, and that's what the governor is supposed to be, and that hers didn't have that. So, and she's using the counterfeit seal when she does her business, right? So everything that she does is counterfeit. So the court has that now, and this is the interesting thing. So I had to email it, and I did that on Thursday, like at 4 o'clock. Like I said, at 5 o'clock, I got a phone call, and another one at like 5:45, the same guy. So I don't know if that was all coincidence or if there was some tie-in where the court called somebody who called somebody and somebody else. I gotta have one more thing I want to show you real quick. Hang on just a second. And this has to do with the statute at large, 106 Stat 4506. Public Law 102, 572, 102nd Congress, to implement the recommendations of the Federal Court Study Committee and other purposes. And it isn't all this on here. I got to find the page it is, so hang on a second. We get down here to this section on Title, I guess that'd be 9, right? Court of Federal Claims. Section 1901, 902, 903. Military retirement pay for retired judges. Huh? That's right. Military retirement pay for retired judges. In general, Chapter 7 of Title 28 United States Code is amended by adding at the end the following new section. Subsection 180, military retirement pay for retired judges. Section 371E of this title, this is Title 28, I believe we're talking about, right? Title 28 United States Code, applies to judges of the United States Court of Federal Claims, and for the purpose of construing Section 371E of this title, a judge of the United States Court of Federal Claims shall be deemed to be a judge of the United States as defined by Section 451 of this title. So in other words, any judge that's covered by Section 451 gets retirement pay from the military. Not just the federal claims courts, because they're doing all that. They're saying they get it based on this other section, 371E, which is referencing 451, which ties them all together, and that's called incorporation by reference. Military retirement pay for retired judges. So federal judges get military retirement pay. Well, what does that mean? It means that they're in the military. Of course, that's what it means. Which would make sense that the judges would be in the military, because if you've ever noticed, the federal judges seem to rule everything. They tell the president what he can do, or they tell Congress what they can do, and they, just some judge anywhere, just some place will, issue an order and say that something is whatever, and, they'll stop doing it. I don't know if they ever say it's unconstitutional. I don't know if they use those words, but whatever words they use. Right? And that would make sense that if the United States is still under martial law, and I have to show you where that came from. I'll go get that right now. Yeah, so if the United States is under martial law in a military government, then the way that they would govern is with the judges, right? And let the civilian population, get back to the light as much as possible, but the courts will be handled by military judges. Just we're never going to them in the proper status to get relief, apparently, whatever their excuse is. But just to show you that, the United States is under martial law, from the War Department, General Order 141, following proclamation by the President is published for information and government of the Army and all concerned. And you have to tie this together then with the Lieber Code, which is General Orders 100. Which says that once martial law has been declared, then it takes a proclamation or a peace treaty. I think there's one other thing for it to end, and none of them have ever happened. So whereas it has become necessary to call into service not only volunteers but also portions of the military. Well, we have volunteer army right now, so this still applies. Of the states by draft in order to suppress this insurrection existing in the United States, and disloyal persons are not adequately restrained by ordinary process of law for hindering this measure and for giving aid and comfort to various ways to the insurrection. Now, therefore, it is ordered that during the existing insurrection, and as a necessary measure for suppressing the same, all rebels and insurgents, their aiders and abettors within the United States, and all persons discouraging voluntary enlistment, resisting military drafts, or guilty of any disloyal practice, affording aid and comfort to rebels against the authority of the United States, shall be subject to martial law and liable to trial and punishment by court martials or military commissions. All right, there at the writ of habeas corpus is suspended in all respects to all persons arrested, or who are now or hereafter during the rebellion shall be imprisoned in any fort, camp, arsenal, military prison, or other place of confinement by any military authority or by the sentence of any court martial or military commission. Well, how would you know if you're in prison in a fort, camp, arsenal, military prison, so forth? Because they're going to be displaying a flag. Army Regulation 840-10 says that the display of the flag of the nation is limited to places to do with the military, other than schools. Schools are the only one of the few options of a public institution that get to display a flag that it isn't a symbol that they're under military occupation. But the post office, the courthouse, the county building, the courtrooms, they all have flags, right? They have gold fringe flags in the offices. So if it has a flag outside, you go inside, see a gold fringe flag. Well, that flag can only be displayed in military offices, including courtrooms. And you walk into a courtroom and there's a gold fringe flag, you just walked into a military courtroom. Don't let them tell you different. I demand trial by court martial. Well, but I'm trying to get around that. I'm just saying that's a stopgap for today, but this is to prove that we're still under martial law. And because of that, the military is in control. And so I want to get my ass back in the military so I can file charges and specifications against the places with gold-fringed flags who are usurping the power of the United States. Right? The imposters, the frickin' people who claim to be the Congress but aren't. The state judges who claim to be state judges but aren't. Or the governor who isn't. All the way down to the frickin' dog catcher. If you want to have any authority over me, brother, you had better have taken the oath to the Constitution. Because it's in the first law passed of the nation, and if you're not going to enforce your first law, well, why would anybody follow any of them? That's where we find ourselves today. They ain't following any of them. We live in a lawless society. All right, enough of my soapbox, so I'm done for today. The United States is a metaphor. And I did surrender to the military authorities, so I hope they take it personal. Send the MP or tell me where to show up. Either way, I'm okay with it. Send the helicopter. Whatever you want to do. Come get me. At least I'll know you're paying attention. Okay, I'm going to leave it there. You all have a great day, and we'll see what happens next. See ya.